And hello, my Everett friends. Just wanted to check in with you and give you a couple of quick updates. First off, um, on our good friend Tony Raymond, who appeared in the Malden District Court today, facing those trumped-up charges from the DeMaria administration of witness intimidation. Today's purpose was to file a motion to dismiss. Unfortunately, I thought it was going to be the hearing today for motion to dismiss, but it was just a file, and Tony will return on May 17th, and the motion will be heard at that time. And hopefully this bullshit case will be kicked out of the courts and back to the street where it should be. So I was going to give you a look at the motion Attorney Bradl wrote. He did a wonderful bang-up job on it. And we'll take a look at a couple of the pieces. Hey. And there's our motion. And as you can see, written on the top, it's out of Malden District Court, docket number 2350, CR 002391, Commonwealth versus Anthony P. Raymond. Motion to dismiss under Commonwealth versus D. Benedetto for lack of probable cause and infringement on a political speech protected by the First Amendment and Article 16 of the Declaration of Rights. That's the Massachusetts Declaration of Rights. And as the opening paragraph reads, Article 16, the liberty of the press is essential to security of freedom in a state. It ought not, therefore, to be restrained in this Commonwealth. The right to free speech shall not be abridged. Massachusetts Declaration of Rights, Article 16, 1780, as amended in 1948. Then it talks about the First Amendment, not establishing any law, or make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people to peaceably to assemble and petition the government for redress of grievances under the U.S. Constitutional Bill of Rights, Amendment 1, 1791. And now comes the petitioner, Tony Raymond, et cetera, et cetera, et cetera. We'll skip right over to the facts. Mr. Raymond offers as evidence the sworn factual statements herein and refers to the police reports filed with the court purporting to establish probable cause. Mr. Raymond is the moderator of Everett Reporter 2, a member-only Facebook community forum where members air political grievances and discuss City of Everett political issues. Mr. Raymond is an online investigative journalist and political activist. He and his colleagues prolifically report on items of public interest and public concern in Everett Reporter 2. He provides the public and some 10,000 cumulative followers across all his sites with original, hard-hitting, fact-based reporting and commentary. He's performing a vital function in the midst of unprecedented political division and destructive warfare between the nation's political camps. He follows leads and gathers evidence to expose corruption and find the truth. Mr. Raymond has exposed the purported victims here in the political arena and contends that the incident case is pure retaliation against his acts of protected free political speech. Mr. Raymond is accused of posting an internet meme, a short repeating video showing a karate figure with three graves behind it with three names, Carlos, Demas, and Slattery. I want to note the footnote that footnote number 1, Mr. Raymond concedes nothing herein, does not admit to posting anything, and proceeds arguendo. The meme and possibly another similar character, the report and complaint read together are not clear, is or are the basis for 2 witness intimidation charges. Whether 1 or 2 memes, the analysis herein does not change and applies to both. Everett police sought a warrant rather than a clerk's hearing for Mr. Raymond's arrest. The warrant was granted, and then police arrested Mr. Raymond while he was working as a bus driver at his bus driver job in front of his coworkers, the most personally damaging manner that could be conjured up by whomever was directing the warrant and the arrest. At arraignment, he was found to be a danger under Section 58A to three specific individuals, Everett town officials, by virtue of allegedly posting internet memes and characters. Mr. Raymond is not dangerous to the named individuals or anyone else. He has been around all three of these individuals for years during his formerly frequent public appearances at City Hall and city events, mere feet away, and there never have been any issues. Mr. Raymond was subjected to the imposition of a GPS tracking bracelet with large exclusive zones from public fora in the town of Everett, the City Hall, and the high school, restricting his future speech and preventing his presence at locations where the expression of political speech is at its zenith. He was warned that he may be sentenced up to 60 days in jail for contact with the named public officials, people he wishes to focus on in addressing the government for a redress of grievances, as is his fundamental right under the First Amendment and Article 16 of our Massachusetts Declaration of Rights. The baseless and wrongful placement of a GPS bracelet has caused Mr. Raymond unwarranted pain and suffering. He had to undergo a knee replacement amidst his monitoring and had to have the bracelet moved to his other leg. He was stigmatized and embarrassed at the hospital when staff viewed the bracelet, making them uncomfortable. He can't take a bath or sleep comfortably during his convalescence. He has to remain plugged into a wall 2 hours a day, and he cannot leave the state. He can barely walk, no less pose a danger to anyone. The exclusion zone caused him serious oppression and forced him to forfeit his in-person First Amendment rights every day. He's required to stay many blocks from City Hall and Everett High School at all times, and an overbroad restriction on his constitutional right to travel. As a result, he cannot reasonably function or travel in his own city. He cannot visit his sister's home or work, and he has to make ridiculous extended detours around the exclusion zones to do errands for his elderly, sick mother-in-law. And then the motion delves into the applicable legal standards, and I'll just touch on a quick highlight on that and move to the conclusion. Okay, so now the motion moves to the elements necessary to prove probable cause, as I referenced at the beginning of this video. And as you can see here on the screen, let me give a full screen for you. There are actually 4 prongs required to establish a threat to commit a crime in the Commonwealth of Massachusetts. So the defendant is charged with having threatened to commit a crime against a person or property of another. Threatening a person with a crime against his or her person or property, a person by threatening a crime against someone else or their property, is itself a crime. In order to prove the defendant guilty of this offense, the Commonwealth must prove 4 things beyond a reasonable doubt. First, that the defendant expressed an intent to injure a person or property of another now or in the future. Second, the defendant intended that his or her threat be conveyed to a particular person. Third, that the injury that was threatened, if carried out, would constitute a crime. And fourth, that the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear that the defendant had both the intention and the ability to carry out the threat. And this is the Massachusetts District Court Model Jury Instruction 6.700 that was revised in January of 2013. So going back, they have to prove these 4 points. And as I said, I don't think they meet one of them. First of all, there was no clear intent to injure any person or property of another then or in the future. The interpretation of the memes that were posted, they're limitless. So there was nothing specific that was intended or even inferred in the posting of that meme. And the defendant intended that his or her threat be conveyed to a particular person. Again, even though names were mentioned in the background there is no specific target, and it can be viewed in a lot of different ways. Third, that the injury that was threatened, if carried out, would constitute a crime. Since nothing was threatened, there's nothing that could be carried out. There was no threats made there, again, stated or implied. And the fourth, that the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear that the defendant had both the intention and the ability to carry out the threat. Once again, it was conveyed to nobody in particular. It was a statement on the really probably the status of Everett politics and the desire to see a new administration come to town at some point in the future. But it definitely did not specifically indicate any intent to harm or threaten an individual. So it not only fails to meet all four prongs here, it really fails to meet any one of them. And I can't see how any way a judge or a jury would not find in favor of Mr. Raymond. Now, as far as the federal case precedents that the courts rely on when it comes to interpreting the freedom of speech, the case is Watts versus the United States. And we have a little video here that will give you a quick explanation on the case of Watts, which was a gentleman that was a prospective Vietnam draftee who was an anti-war protester and had no intentions of going to war, and made his feelings known. He was arrested for threats against the President of the United States. He was found guilty in district court. He appealed. They upheld the conviction, and the case went to the Supreme Court. And here's what the Supreme Court had to say.
Hyper Quickie. As we've discussed before, just because there are some exceptions to the First Amendment doesn't mean that your exception is valid. A true threat is an exception because it creates harm beyond just your speech. But as the Supreme Court found in Watts v. United States, political hyperbole does not in any way count as a threat, no matter how much you might hate the guy or how orange he appears. In August 1966, Robert Watts, an 18-year-old African-American, was protesting the Vietnam War at a rally at the Washington Monument. Watts was overheard saying that he just received his draft classification and had to report for his physical. He was quoted as saying, "If they ever make me carry a rifle, the first man I'll get in my sights is LBJ. They are not going to make me kill my black brothers." The person who overheard this was an investigator for the Army Counterintelligence Corps, and so Watts was arrested for threatening the president and was convicted by a jury, the D.C. Court of Appeals confirmed. Although the Supreme Court upheld the statute prohibiting threats against the president, Watts' utterance wasn't actually a credible threat. It constituted political hyperbole made during a protest, which violated two First Amendment rights: his right to free speech and his right to petition the government for redress of grievances. To be credible, the threat would have to express a condition that could actually happen. But do they make a habit of having LBJ in the room when they first give a soldier a loaded rifle? In a concurrence, Justice William O. Douglas said, "The Alien and Sedition laws constituted one of our sorriest chapters, and I had thought we had done with them forever. If you can take any hyperbolic comment of a government official made at a rally or on social media or whatever and make it constitute a true threat for the purpose of prosecuting someone of a crime, then the First Amendment is dead in the water.
And that explains it. So, as you heard right there, very serious situation where a young man threatened to shoot LBJ if he was forced to pick up arms in defense of the country, and that LBJ would be the first one he would point the weapon at. And in short analysis, what it came down to is it was realized that there was no way that could be a realistic threat. That number one, the man would never be inducted into the U.S. Army. And or furnished an M16. So since it was something that was a fantasy, basically, it couldn't be considered, an actual threat, and falls in the category of political hyperbole. And to say that Tony's case even comes close to that is crazy. He issued no threat. Anybody that knows the people that claim to be threatened by Tony knows that this is a ruse, that they're doing this to shut him up and for no other reason. Nobody fears Tony Raymond, especially anybody in the DeMaria administration, and that's just the way it is. So Watts versus U.S. made it plainly clear through the Supreme Court decision that the political hyperbole is definitely a protected element of free speech and First Amendment. And on page 8 of the motion, Attorney Bradl takes time to point out a couple more examples of political hyperbole that far exceeded anything Tony Raymond had done. So let's take a look and check out the references. On page 8, for example, he says, even repugnant expressions are protected, from hanging an effigy in the town square in the 1770s to comedian Kathy Griffin appearing on the cover of a major news magazine holding the bloody severed head of Donald Trump. This is because amidst heated and pointed political debate, Americans have made a value judgment as expressed through the First Amendment, as interpreted by the Supreme Court, that these expressions do not seriously threaten what they assert, but are stated to establish important political points and thereby protected as political hyperbole, and see in this document. So the individual's alleged fear does not justify the restrictions and must yield to Article 16 and the First Amendment. And heading into the conclusion, Attorney Bradl makes it quite simple and straightforward. There is no doubt that Mr. Raymond is addressing matters of public concern as a journalist. Grotesquely, the government has sought to transform these time-honored journalistic expressions into felonious witness intimidation. Mr. Raymond is experiencing a pronounced chilling effect on his ability to continue to scrutinize and criticize the Everett administration, and is trying to function as a professional investigative reporter under a prior restraint on his speech. For all the foregoing reasons, the court should dismiss the charges as a matter of law under Article 16 and the First Amendment. Hoo-ha! Good job, Attorney Bradl. Turn on May the 17th, I believe it is, to the same location, Malden District Court. And on that day, they'll have the opportunity to argue that motion. And of course, I presume the plaintiffs will have the opportunity to argue against it. Whether they will actually show up and do that remains to be seen. But it's plainly clear that this arrest was a complete sham. It was way outside of the bounds of decency and fairness. And it just shows really how underhanded and desperate the members of the D-Murray administration are at this point. And I hope you'll take some time and show up for Tony on the 17th. We'll continue to follow any developments that come along in this. And if there is fairness and there is justice in this world, this will come to an end very shortly. And I hope Tony takes due recourse and pursues all rights available to him for what's been done. It's to say it's an injustice is simply an understatement. So until next stream, thanks for listening, and give Tony a shout. Hop on over to his GoFundMe page and see if you can kick a couple of dollars in there. As we said before, the cost of a defensive like this is exceeding six figures, and so it's well over $100,000. But in the end, I think it'll be worth it. It'll, as well as clear Tony of the unjust charges, it'll also send a resounding message to the administration that we're not going to lay down and take a beating. So, be well. Best to you. Have a good week. And until next time.
It's such a crock of shit.